And so after oral arguments are presented to us, and they could be waived, oral arguments could be waived, or it could be that the law is well settled, and so there's no need for oral argument. And but in those situations where we have oral arguments presented to us, then we, the three justices, after hearing the arguments, go in and conference the cases and talk about them. And of course I can't talk about the cases that I've heard or what goes into our decision-making process, deciding particular cases that have been heard by the court or that are pending before the court. The law prohibits me from doing that. And actually it's a Class A misdemeanor for a justice to discuss cases that have been before them in the decision-making process, or cases pending before the court. But we, the three justices, will discuss them, and the law that applies in those, and address each issue that has been presented to us. And then we will come to a decision, either to affirm or to reverse and remand the case, or to reverse and render a judgment, and then one of the justices will be assigned to write the opinion in the case. And we do that on a rotating basis. We have a pick order, if you will, where if I'm first pick, then I'm probably going to get the less complicated case on the docket, the least complicated case on the docket. If I am third pick, then I'm probably going to get the one that no one else wants to write on. So, but it all evens out, and the first, second, or third pick, all on a rotating basis, and so you're going to get the hard ones, you're going to get the easier ones, and the ones that just fall somewhere in between. So we this process continues every week. We have some weeks we call our NORA docket. We have our NORA dockets, which stands for no oral argument. Those where oral arguments is waived, or we believe the law is so well settled that we don't need to hear oral argument. And but we are then assigned in those cases to write a particular justice assigned to write an opinion on cases that are assigned to us on the NORA docket as well. And I want to speak with you about judicial philosophy and why it's important, in my view, to have conservative judges. And not just in the trial court, and it's, in my view, important for your trial court judges to have a conservative judicial philosophy, not to just decide a case based on what they think the law should be, or what they want it to be based on their own personal belief or political agenda. On the appellate court, we must, within the narrow confines of the law, apply the law to the particular facts and issues before us. We are not deciding, we're not legislating, we're not deciding what the law should be. We are just taking the facts that have been presented to us, what occurred at the trial court level, the issues, within the issues. We're not creating issues. We're just addressing the issues that the lawyers or the pro se litigant has presented to us in their briefs and argued to us if they do. And then applying the law very narrowly to those specific issues, and then ruling in accordance with the law. And I want to talk about, just address 3 reasons why I strongly believe that judges should strictly interpret the Constitution and laws as written. and not make law, not just make law based on what they think it should be. First of all, every time that I have been elected a judge, and even appointed judge, and that's a total of 5 times now, 4 times elected countywide as a criminal district judge, and then appointed, was sworn in on December 4th as a justice on the 5th District Court of Appeals. I take an oath to preserve, protect, and defend the Constitution and laws of this state and of the United States. And if a judge is true to his or her oath, then he or she will do just that. And to go off on, deciding a case based on what they think the law should be is just, well, I mean, it's wrong. Against the oath that the judge took when the judge took office. And secondly, it's not what you elected us to do. You all elect your state legislators to decide the laws that the legislator, based on hearing and listening to the constituents, believe are in the best interests of the people. That's what you elect your state legislators to do. You don't elect the judges to do that. You elect us to decide cases based on the law and the evidence, and to strictly interpret the Constitution and laws as written. And I strongly believe that. And I strongly believe that judges who, well, let me just, I have to be careful about what I say, but I don't know how to put this really, but I was a trial court judge for almost 15 years. And there were things that I did, decisions I had to make sometimes that necessarily, were, if I were to decide just based on my personal, what I believe personally, I might not have decided it that way. But I decided it strictly based upon the law and the evidence before me. And that's why I had to make some tough decisions as a criminal district judge.